Today's legislative hearing on H.R. 3593, H.R. 4261, H.R. 4281, and two pieces of draft legislation. The five bills we will be considering today are the product of extensive investigations conducted by this subcommittee in the course of its oversight duties that have revealed poor judgment, chronic mismanagement, and a general lack of accountability by the Department of Veterans Affairs. These bills are intended to heighten protection for our veterans and improve services provided by the VA. First, we will hear about H.R. 3593, the VA Construction Assistance Act of 2013, which Ranking Member Kirkpatrick and myself introduced on November 13th, 2013. This bill recognizes the tremendous problems associated with VA major construction projects in Aurora, Colorado, New Orleans, Louisiana, and Orlando, Florida, as identified by an O&I investigation and substantiated by a GAO report. According to these findings, VA is delayed an average of 35 months with an average cost overrun of $366 million. This legislation requires the VA to use the Army Corps of Engineers as a special project manager to assist in completing these projects closer to their original budget and completion dates. Notably, this bill is supported by the Veterans of Foreign Wars, the American Legion, and the former Secretary of Veterans Affairs, Jim Nicholson. Second, we will address H.R. 4261, the Gulf War Health Research Reform Act of 2014, which I introduced last week along with Ranking Member Kirkpatrick and full committee Ranking Member Michaud. This bill reinstills the independence originally expected of the Research Advisory Committee for Gulf War Illnesses, which includes overseeing VA's research on Gulf War illnesses in order to improve the lives of those suffering as a result of such illnesses. Third, we will hear about H.R. 4281, the Protecting Business Opportunities for Veterans Act of 2014, sponsored by the Honorable Tim Huelskamp of Kansas. H.R. 4281 will make tremendous strides at holding accountable the bad actors that attempt to defraud service-disabled veteran-owned small businesses and other veteran-owned small businesses of crucial set-asides they receive in business. Fourth, we will discuss a piece of draft legislation entitled the Biological Implant Tracking and Veteran Safety Act of 2014. This legislation requires the VA to implement a standard identification protocol for biological implants that is consistent with the FDA's unique identification system. The system must allow for the tracking of implants from donor to recipients. This bill also requires the VA to procure biological implants only from vendors using the system and only through competitive procurement processes. Ultimately, this legislation will improve VA's ability to prevent the implantation of contaminated tissue and also to notify veterans in cases of FDA recalls. Finally, we will hear about the draft directive titled the Veteran Information Security Improvement Act of 2014, which is sponsored by the Honorable Jackie Walorski from Indiana. This IT security directive is designed to assist VA in mitigating known information security weaknesses and prevent, limit, and detect unauthorized access to its networks and systems. It also identifies detailed actions and tasks consistent with current federal requirements that should be taken by VA to address its longstanding information security challenges. Once again, I would like to thank all those in attendance for joining us in our discussion today. And I now recognize Ranking Member Kirkpatrick from Arizona for 5 minutes to discuss her opening statement.
Thank you, Mr. Chairman, for holding this hearing. Holding hearings on proposed legislation within the jurisdiction of our subcommittee is one of the most important legislative duties we have. These hearings enable us to gather the viewpoints of the Department of Veterans Affairs, veterans groups, and those with specific expertise regarding the matters under consideration. It's important that we gather these views and thoroughly consider them as we deliberate which bills this subcommittee will forward to the full committee. We in Congress should never assume we have all the answers. That's important to remember as we consider the often blunt tool of legislation. If we truly seek the most effective ways to accomplish a policy goal, then we must carefully consider the views of stakeholders, including those who would enact the policy and those whose lives would be affected by it. At the end of the day, we are all striving to fix problems and improve the services and benefits that VA provides for veterans. This shared priority is a reflection of our nation's commitment to our veterans. I note that the VA is able to provide comments on only 2 of the bills before us today. I ask that the VA provide us with its comments regarding the other bills as soon as possible so that we may be able to consider the department's views going forward. I also ask that all of our witnesses provide us their views on any of the bills that they have not had time to include in their testimony. I also ask, Mr. Chairman, that in future legislative hearings, we try as hard as we can to set the agenda early enough to provide all of our witnesses with the time they need to provide us with their thoughtful views on the bills before us. There are 2 bills before us today that I have co-sponsored with the chairman, H.R. 3593, the VA Construction Assistance Act of 2013, and H.R. 4261, the Gulf War Health Research Reform Act of 2014. I especially look forward to hearing from our witnesses regarding these bills. Again, thank you, Mr. Chairman, for holding this hearing. I look forward to hearing from our witnesses, and I yield back the balance of my time.
I thank the ranking member. Mr. Hulskamp, you are recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate the opportunity to testify in support of H.R. 4281, the Protecting Business Opportunities for Veterans Act of 2014. Over the years, this committee has heard testimony, received Inspector General reports, and heard reports of numerous businesses who we believe took advantage of set-asides rightfully reserved for service-disabled, veteran-owned small businesses. As a member of this subcommittee, as well as the House Small Business Committee, I believe the evidence, fraud, and abuse of these programs requires stricter oversight and enforcement. This act would apply to small business concerns owned and controlled by a veteran with a service-disabled disability, as well as small businesses controlled by veterans who receive federal contracts from the VA. The bill simply requires that upon receiving a contract with the VA must obtain a certification that the business concerns will comply with the requirements already written into the law. In particular, it will address how the recipient of the contract will meet the requirement that 51% of the contracted service or work be performed by a veteran-owned business or a service-disabled veteran-owned business. Those receiving a contract will be required, 1, to certify to the VA that they meet the specific performance requirements already in law, and 2, acknowledge that the certification is subject to the false statement penalty under the U.S. Criminal Code. Furthermore, this legislation will require the Office of Small Business and Disadvantaged Business Utilization and the VA's Chief Acquisition Officer to implement a process to monitor compliance and ensure violations are reported to the Office of Inspector General. The IG is then required to file an annual report to the House and Senate VA committees showing the number of small business concerns suspended or debarred from federal contracting and those referred for prosecution for violating the certification requirement. The intent in this bill simply is to provide law enforcement with the necessary tools to crack down on contractors who use pass-throughs and other methods to take advantage of set-asides rightfully reserved for veterans. An affirmative certification at the time of the award constitutes strong evidence of the knowledge and intent to deceive if a contractor is later found they have not been eligible. Finally, the bill is necessary to direct the OSDBU and the VA Chief Acquisition Officer to do what they should be doing all along, that is to monitor and enforce compliance. The Protecting Business Opportunities for Veterans Act will ensure those rightfully deserving of the contracts have access and put in place tougher enforcement mechanisms to ensure those wishing to exploit the system are caught and held accountable. And with that, I yield back the balance of my time. Mr. Chairman, thank you.
Thank you, Mr. Hillscamp. Ms. Walorski, you are now recognized for 5 minutes.
Thank you, Mr. Chairman. This directive stems from feedback the committee received regarding the members-only briefing held on December 3rd, 2013, which the VA's Office of Inspector General, and the Government Accountability Office all attended. At this briefing, the committee provided an overview of VA's information security vulnerabilities using VA's own internal documents and previous testimony from VA's Inspector General. Recognizing the importance of protecting the personal information of their constituents, many members of Congress have asked the committee to take all steps necessary to strengthen IT security within the VA. In addition to the December briefing, the committee held numerous meetings and discussions, sent information security-related letters, and held a hearing in June 2013 to address IT security weaknesses. Unfortunately, VA's lack of response, cooperation, and dialogue has been a long-standing issue that continues to this day. During the December briefing, independent information security experts verified HVAC's findings about the VA's critical network vulnerabilities, including the following. VA's network had been compromised at least 9 times since March 2010. Within VA's 420,000 computers, there were 5 vulnerabilities on at least 95% of these computers. VA employs tens of thousands of outdated operating systems. Because of VISTA's vulnerabilities, VA stated that a data breach to financial, medical, and personal veteran and employee protected information will occur with no way of tracking the source of the breach. Over the past 20 years, VA's independent auditor, Office of Inspector General, and the GAO have all reported persistent weaknesses in the VA's security, placing veterans' personal information in jeopardy. In fiscal year 2013, the VA's independent auditor reported material weaknesses in IT security for the 12th year in a row. The VA's Inspector General identified VA's lack of effective information security controls as a major management challenge. The IG's upcoming FISMA audit provides 35 recommendations for improving VA's information security program. 32 of these recommendations are identical to recommendations included in the previous year's audit. The GAO has found VA's IT security issues since the late 1990s. Since 2007, the GAO has found major weaknesses in each of the 5 major categories of information security controls at the VA. The number of incidents affecting VA's computer systems and network has risen over the last several years. VA system serves as a gateway to many other federal IT systems. Given the goal of integrating electronic health records with the DoD and the eventual future connection of the National Healthcare Program, securing the VA's IT system is critical. VA's persistent, decades-long IT security weaknesses highlight the need for stronger, more focused action to ensure that the VA fully implements a robust security program. Despite OIG's testimony and the committee's evidentiary documents that originated within the VA itself, VA officials did not concur with our findings from the briefing, including that critical security vulnerabilities do exist and that the domain controller remains compromised. It's important to understand the critical nature of the security failures we're discussing. Not only do these failures disrupt the daily transactions between the VA and the veterans, but they're incredibly costly. The VA IT security failure in 2006 that impacted 26.5 million veterans cost the VA $50 million just to mail out data breach notices. Given VA and OIT's more than $3.7 billion budget and thousands of employees, these numerous security flaws are unreasonable and irresponsible. These failures are not due to a lack of resources. They're due to a lack of priorities and proper federal guidance. I'm confident this directive will provide the VA with a clear roadmap, prevent ambiguity, and take away any guesswork in order to achieve a risk-based approach to address each of these challenges. The GAO has agreed and stated that if the directive is implemented, it will allow VA to refocus its efforts on steps needed to improve the security of its systems and information. This bill itself establishes an explicit plan of action to resolve VA's IT security weaknesses as identified by the committee, GAO, VA, OIG, and others. This plan is taken from a common federal and industry best practices. Specifically, the bill directs the Secretary to reclaim, secure, and safeguard VA's network, including their domain controller, defend workstations from critical security vulnerabilities, upgrade or phase out of unsupported and outdated operating systems, secure web applications from vital vulnerabilities, protect VISTA from anonymous user access, and comply with federal information security laws, OMB guidance, and NIST standards. To improve transparency and accountability, the bill directs Secretary to submit to the committee a biannual implementation report, including a description of the actions taken by the Secretary to implement and comply with the directive. The VA OIG will also be required to submit to the committee an annual report that includes a comprehensive assessment of VA's execution of the directive. Finally, on a monthly basis, the Secretary shall submit to the committee reports on any discovered security vulnerabilities. Thank you, Mr. Chairman. I think our veterans deserve better. Thank you.
Thank you, Ms. Walorski. Our first panel is now at the witness table, and I thank you for being here today. We will hear from Ms. Stella FIOTES, Executive Director of the Office of Construction and Facilities Management for the Department of Veterans Affairs. She is accompanied by Mr. Tom LENEY, Executive Director of the Office of Small and Disadvantaged Business Utilization of the Department of Veterans Affairs. Ms. FIOTES, your complete written statement will be made part of the hearing record, and you are now recognized for 5 minutes.
Thank you. Good morning, Mr. Chairman, Ranking Member Kirkpatrick, and other members of the subcommittee. Thank you for the opportunity to be here today to discuss VA's views on pending legislation, including H.R. 3593, the VA Construction Assistance Act of 2013, and a draft bill that concerns compliance with VA small business programs. Mr. Chairman, I'd like to ask that our written statement be entered for the record. Mr. Chairman, VA is not testifying on all the bills on the agenda today. Draft bills on Gulf War illness research matters and VA IT security programs were not received in sufficient time to prepare and clear administration views. I want to ensure the subcommittee understands we are not dismissive of these remaining bills or your interest in them. This was purely a matter of having sufficient time to prepare well-developed and helpful formal views on complicated subjects. As noted in our written testimony, we will be following up for the record on the remaining bills, and we are glad to brief you and your staff at your convenience on the subject matter covered by those bills. I will speak to H.R. 3593 first. VA appreciates the strong interest and support from the subcommittee to ensure that our major construction projects are delivered successfully. I would like to make the point that VA has a strong history of delivering facilities to serve veterans. In the past 5 years, VA has delivered 75 major construction projects valued at over $3 billion. However, we also fully acknowledge our challenges on the major construction projects that have been the subject of a great deal of dialogue with you and other stakeholders. We are committed to continuing that dialogue. VA, however, does not believe that the approach outlined in the bill will achieve the desired results and thus does not support it. While there have been challenges with our projects, we have taken numerous actions to strengthen and improve the execution of all of VA's ongoing major construction projects and ensuring the department's future capital program is delivered on time and within budget. These include implementing the recommendations from the GAO and the department's Construction Review Council, including the specific actions that would be required in Section 3 of the bill. Therefore, we don't believe Section 3 of the bill is necessary. Section 4 of the bill would require that VA enter into an agreement with the Army Corps of Engineers to procure a special project manager to oversee VA major construction projects for facilities in Denver, Orlando, and New Orleans. VA believes the creation of a special project manager would be problematic in the management and supervision of these projects. The bill raises serious questions about the contractual relationship between the VA and its contractor, potential confusion on the lines of authority the special project manager will have vis-a-vis the VA and the Corps, and the effect upon the independent exercise of discretion by the VA contracting officer, who is ultimately responsible for managing the contract on behalf of the government. VA, however, continues to be open to consultation and collaboration with the Corps or other specialists outside VA. We continuously evaluate our processes and delivery methods for each lease and for each construction project on its merits, and we benchmark industry best practices with several agencies, including the National Institute of Building Sciences, GSA, and the Corps. When VA determines that the best delivery strategy is to employ another agency, such as the Corps, this strategy is used. In fact, VA and the Corps have a long history of working together to advance VA facility construction and share best practices. Our current discussions with the Corps are a logical evolution of that relationship. Mr. Chairman, thank you for the opportunity to present views on this bill. I'd like to now turn to my colleague, Tom LENEY, who will address the bill regarding service-disabled veteran-owned small businesses.
Good morning, Mr. Chairman, Ranking Member Kirkpatrick, and other members of the subcommittee. Thank you for the opportunity to discuss the draft small business measure that the subcommittee asked us to review. Mr. Chairman, we understand that the H.R. 4281, the Protecting Small Business Opportunities for Veterans Act, was just introduced on Friday, March 21st. It differs substantially from the draft that we received earlier, and the VA has not had the opportunity to comprehensively review this new text. You have our views on the original draft bill. I will provide some comments to the subcommittee regarding our preliminary analysis of the version introduced late last week as 4281. The VA understands the committee's interest in veterans complying with the rules on limitations of subcontracting. As the VA procures more dollars and awards from SDB OSBs than the other civilian agencies of the government combined. Unfortunately, this draft bill only applies to veteran-owned small businesses that are contracting with the VA. We think it unfairly singles out veterans and places an unfair burden on those businesses that would not be required of any other small businesses or at any other agency. Tools exist that we believe can meet the aims of this legislation. For example, monitoring the amount of work passed to subcontractors is required of contracting officers under the current federal acquisition regulation. In addition, the VA has established a subcontracting compliance review program that audits prime contractors to ensure compliance with this provision. We believe processes such as these enable us to achieve the objectives set out in the legislation. Thank you for the opportunity to testify before the committee today. Ms. FIOTES and I look forward to answering any questions the committee may have.
Our thanks to the panel. Okay, I'm sorry. Okay. Ms. FIOTES, in Denver, VA asked for bids based on the presumption that it would produce a $604 million project for the hospital, but it appears VA has produced potentially $1 billion incomplete design, which they provided 8 months after the bid process was completed. How can VA prevent such loss of control in future designs?
Mr. Chairman, we believe that the project designs we have delivered, albeit somewhat later than originally anticipated, are in fact able to be constructed within the appropriated amount for this project.
Ms. FIOTES, you referenced the new Las Vegas facility in your testimony as an example of VA completing major construction. However, according to the GAO report, Las Vegas was $260 million over budget and 74 months late. So is this representative of VA major construction efficiency, this project?
Mr. Chairman, in our response to the GAO draft report, the VA outlined that it did not agree with the methodology the GAO was using to assess time and cost against these projects. Starting at some point in the very early planning stages when the project and not even the site were actually defined, and then taking that number and that schedule as the basis for comparing to what ultimately happened many years later with a real design and a real site and a real construction project, we believe was not an accurate depiction. So we would argue that the time and the cost should be judged against the appropriated amount by Congress at the time the construction is bid, and in that sense we would state that the project was in fact delivered on time and on budget.
So you're saying that are you saying that this project was delivered on budget and on time, the Las Vegas project?
Based on the way that we account for time and budget, yes.
Wow. Well, the GAO obviously differs with you, and I think what was so compelling about the GAO report was that in the report it referenced the Army Corps of Engineers as building the same projects, or what it called similar projects, for the Department of Defense on budget and on schedule. Ms. FIOTES, do you believe that contractors submit excessive or unwarranted change orders to drive up costs or cause delays, how does VA manage the change order process?
Mr. Chairman, the change order process is a very critical process in the duration of the construction of any large complex project. And we recognized, as did some of the GAO reports, that our process was too lengthy and too cumbersome, resulting in delays in the execution of the change orders and the payment of those change orders. We have since addressed those challenges. We have put in place new policies. We've established metrics for the change orders. We've added staff. We've added legal counsel to help us with the review of the change orders. And we are in a much better position now and are processing our change orders at a much better rate than in the past. We hope within the next several months to be completely caught up with our backlog.
So when the GAO report says that VA's, these major medical construction projects are delayed an average of 35 months each, with an average overrun of $360 million each, you differ with GAO and you say that you can produce accounting standards that erase those delays and erase the amount that's over budget? You can come up with that?
Mr. Chairman, I didn't reference accounting standards. I just referenced our response to the GAO, which the GAO included in their final report, although they did not agree with our approach. It is that we measure time from the time a construction project is awarded, not from the time it is conceived, and we measure cost from the time the full amount is appropriated, not from the time the project was conceived. That was the difference between our evaluation of time and schedule and the GAO's evaluation.
Well, it's whatever you say it is on any given day. Ranking Member Kirkpatrick, 5 minutes.
Thank you, Mr. Chairman. Thank you for your testimony today, and we want to, help to solve this problem and get these construction projects completed so they can serve our veterans. And my line of question is going to be addressing two things. One is basically the construction management and using USACE, and then I also want to talk a little bit about the bid process. So those would be my lines of questioning. First, has the VA used USACE to manage any major construction projects recently?
Ranking Member Kirkpatrick, we have not used them for major construction projects. However, we have used the Corps for a number of minor construction projects and more recently in construction projects for our National Cemetery Administration as well.
Have you done any quantitative studies between the Corps' overhead and your internal overhead, as opposed to when you use them? I mean, is there a difference in the overhead costs?
I haven't. I don't have those facts before me. We could compare those. I'm not sure what the numbers are. I just don't know if we've done that because those projects, the minor projects, are not in my jurisdiction. They're completed by the Veterans Health Administration. But we could certainly get some more information if you'd like.
Does it make sense to you to use the Army Corps of Engineers in major construction management projects?
Again, Congresswoman, as I said, we evaluate each project on its merits, and if there were a case where we had a major project that we wanted to undertake with the Corps, we would have to enter into early discussions with them way before the time that we would award a construction contract to see if that would be an appropriate vehicle to use. And we've done that, as I said, with numerous minor projects.
Okay, let me go quickly to the bid process, and we may go back to the management. Although your testimony doesn't address the use of design build versus design bid build, the legislation we're proposing requires design build to the extent practicable. Can you enlighten the committee on the advantages and disadvantages of each of the types of bid process, design build versus design bid build?
Congresswoman, the design build delivery method is a method where the architect and the contractor are awarded one single contract, and the contractor has the responsibility to deliver the design as well as the construction of the project. The traditional design bid-build process is where we have a separate contract with an architect engineer to develop a design, 100% design, and then go out to bid and hire and award a construction contract to a separate contractor to build the project. There are advantages and disadvantages to both. The traditional method allows for a complete design and for input of the user and the facility during the development of the design. The design build process takes a little bit more of the design out of the control, if you will, of the user and puts it in the hands of the contractor. It is said to save time in some instances. And again, it's a case-by-case basis. I will tell you that I have used design build in previous contracts. We have used design build at the VA for certain projects. Traditionally, the very complex projects, such as the medical centers we're talking about, would probably not be the best suited for a design build, because it would be very difficult to just describe the performance requirements and then leave the design completely up to somebody independent of the users. But we have, in certain cases where it was just a single, more standard type of construction project, we have used design build. And we are considering using it in the future as well. So it's a case-by-case analysis of the project and what best suits it.
One quick last question. Are change orders treated differently depending on whether it's a design build or design bid build?
Yes, they are.
And how is that different?
In the design bid build process, the contractor has bid on 100% design documents, and therefore any changes from those documents that happen either because of a government proposed change or because of unforeseen conditions must be submitted by the contractor to the government for an independent estimate and then an issuance of a change order for the amount that the government deems appropriate for that change. In the design build process, there are fewer opportunities for the discussion between the government and the contractor on change orders, because the contractor has taken on some of the risk of changes since he has developed the design as well. That is not to say that there are not changes, and in the design build process, when there are changes, they are usually much more expensive.
Thank you. I've gone over my time. Thank you for allowing me, Mr. Chairman.
Thank you, Ranking Member Dr. Rowe, State of Tennessee.
Thank you, Mr. Chairman, and I want to delve in further what Ms. Kirkpatrick was talking about, something I have a lot of experience with, having been in the process of building 3 hospitals, 3 medical office buildings, schools, public buildings for the city of Johnson City, Tennessee. So I'm very familiar with the bid process and change orders. And literally, it should be embarrassing to the VA, this Orlando. I mean, I think the Cubs are going to win the World Series before that hospital is finished in Orlando, Florida. I think that's a possibility. So anything to speed it up, because money spent with what happened down there is not money spent on some other needed project the VA has. So I'm going to go with what we did. Very, very simply, there are 2 ways. You very well stated out what a design bid build is and what design build is. And they both have advantages and disadvantages. What I like about the design bid build is that when we would build a school, for instance, at home, we would build in probably about 10% change order. We knew there were going to be some change orders. Once you get started, there are things when you've designed it as well as you can with your architect, and you've had a sealed bid and a qualified contractor bid on it, you know you're going to run across some things in there that weren't anticipated. So we build about 10%, and sometimes you don't. And what you described is the way it should be done. If you hit something that needs to be changed, it comes back. We would vote on it in the city council, approve that change order or not approve it, and go on. So I think that is a very good way to do it, and to have and what we hired, we learned this very early on. We hired our own person to look, not just have the contractor there. And that's why I think having a supervisor in the Corps of Engineers is a great idea, because you've got a third party who can look after your interests and watch over that project. And we hired someone in the city of Johnson City, a former contractor, to do that very thing. They would look over every building structure that we put up. He was there every day, several days a week at least, looking over and supervising that along with it and working with the contractor, not as an adversary, but looking after it, but looking after our interests, the taxpayers and city people. So I would think that would be a good thing, that you all would want that, and to have an objective third party out there like the Corps, who's not involved with the VA, to overlook your project. I think it'll slow things down. I think it'll make it better for you. I would encourage you to look favorably on that, not unfavorably on that. Any comments?
Congressman, thank you for your remarks, and I agree with the way you've laid out the challenges, particularly with the change order process. We don't believe that the establishment of this special project manager will aid the project because of the complex contractual relationships between the VA and the contractor, the responsibilities of the contracting officer as the arm, if you will, of the government in implementing the contract, and then the uncertainty of the role and the authority of this special
Why would it
project
work where I was? Because it worked great. I mean, it was, we felt like our interests were being looked after on the job site when we had someone there who knew what they were doing, who was in the construction business, who could tell us, no, this is not being done, or why would it work there and it wouldn't work at a VA site?
Well, and I can't comment on the specific contract and the specific project, but I can tell you that we do have numerous project team members and project executives looking out for the
who was looking after
government.
Orlando?
I'm sorry?
Who was looking after Orlando and Denver and Las Vegas, these other projects that have not gone exactly like I think anybody wanted them to?
And I agree that we have run into challenges, and I can't speak any more about the Orlando challenges because I think we have, excuse me, spoken about those in the past. But I think that the cooperation and the collaboration with the Army Corps of Engineers could be a benefit to the VA and to the project if it is the right type of collaboration.
I agree 100%. I mean, I think I'm looking at.
We just don't think that the project manager may be the best vehicle.
I think a project manager, someone who's there to look after our interests, the taxpayers, the veterans' interest, to make sure this project done's right, and to point it to work with the contractor, not as an adversary. We didn't have that relationship with our contractors. And I think you'll find it works very well. I'm surprised that the VA has a reluctance to do that. Mr. Chairman, I see my time's expired. I yield back.
Thank you, Mr. Rowe. Mr. Waltz? Ms. Walorski?
Thank you, Mr. Chairman. Ms. FIOTES, does the VA make sure that its prime contractors use surety bonds with their subcontractors to ensure timely payment?
Yes, we do, Congressman.
On all projects?
On all our projects, yes.
Thank you, Mr. Chairman. I yield back.
Mr. O'Rourke?
Thank you, Mr. Chairman. Want to see if I can better understand some of what we're talking about. And so I understand that you don't agree with the conclusions that the GAO has reached. And when the chairman was asking about the Las Vegas project in particular, you talked about a difference in terms of when you begin to measure the costs outlaid and the start of the clock for the construction, not when the idea was conceived, but when the funds were appropriated. But would you accept the thrust of the argument that projects are taking too long to complete and are too expensive or more expensive than they should be?
I can't necessarily agree with that if we look at the projects at the time that they are fully scoped out with their requirements clearly defined, with an appropriation that matches the requirements that have been submitted. I can't say that we exceed the cost after that point. But if the project spends too much time trying to get to that point. That is a problem, and that challenge we have recognized. We have recognized that when the Construction Review Council, chaired by the Secretary, looked at some of those projects, and we recognized that the early stages of planning needed to be strengthened, and we needed to be very clear in defining our requirements and our scope before we came to Congress asking for money. And we have put that in policy, and we no longer submit projects going forward for appropriation, for construction appropriation, unless we have 35% design completed. That gives us the confidence that we have established the requirements, we know the basics of what the design is going to look like, and we have a substantive budget that we can base our request on. I don't think that that was happening in the past, and some of the projects that we're discussing happened before these policies were put in place.
I appreciate that, and in my perspective, in my job representing El Paso, is the fact that our VA facility, proposed VA facility, which is to be co-located with the active duty military hospital in El Paso, is number 79 on that skip list, which is the list of all capital projects that the VA has yet to construct. And so if I understand the improvements in the processes that you just described, but if you're unable to acknowledge that the hundreds of millions of dollars in individual projects over what they were initially conceived to be, and that the amount of time that we're taking to complete these is a problem and needs a more urgent corrective action to resolve it, it's deeply troubling to me as number 79 on the list for a facility that is desperately needed in El Paso, where we're sending folks on a 10-hour round trip to get care that they should be able to receive in the community. So I hope you understand where I'm coming from on this, and I agree with our ranking member who said, you know, we should only, with the greatest hesitation, move forward on legislation because it is such a blunt instrument. And you're the subject matter expert in this, not me. So I want you to be able to come up with the best possible solution to the problem we have. But it's hard for me when it doesn't seem like there's an acceptance of the problem, or at a minimum, a very wide gulf between what you're hearing up here from the folks who represent these communities where we have these large cost and time overruns, and then what you're saying, which is, you know, I guess changing when a difference of opinion about when the clock starts. You know, by the time you start the clock on our project, we're, you know, a decade plus out from start. So that's where I'm coming from, and it makes me more likely to support this legislation when I don't hear, in terms that at least I can understand, an admission of the problem and how it is we're going to fix it with the urgency required, not only to fix the current problems, but to get to those that are, you know, further down the line on that skip list.
Congressman, I don't disagree that our process needed fixing, and that is what I was trying to describe before when I said that we recognize that we were not doing a good job of planning up front and establishing the requirements and nailing down the scope before we came to Congress to ask for an appropriation. And that is what has caused what appears to be a series of cost increases. The fact that the project started as a shared facility somewhere and ended up being a standalone replacement hospital on its own campus over the span of several years, of course added millions, hundreds of millions of dollars to the cost. That was our fault. We were not doing a good job of planning before we came to the Congress. We do acknowledge that, and that is the reason that that was the #1 recommendation from the Construction Review Council and the #1 priority to implement, that we would not bring forth projects that were not thoroughly thought through, thoroughly designed, and with a good, solid budget before we asked for money. So no, I did not say that we did not, that we did not have issues. I just said that the way the GAO report presented the cost escalations, we did not agree with.
I appreciate that. My time has expired, but I would love to follow up with your office after this to find out how this impacts not only the projects that we've identified today, but those much further down the line, like number 79 on the skip list. So
I know we owe you that, Congressman. We talked about it last time. We just didn't make it happen yet. We will.
Thank you. Thank you, Mr. Chair.
Thank you. Mr. Hulskamp?
Thank you, Mr. Chairman. Mr. LENEY, I appreciate your testimony. I appreciate that you haven't had a full opportunity to review HR 4281, but a couple questions just on the program, and I'm looking back at the GAO report from last August, or over a year ago, I guess, longer than that, August 2012, indicating the program remains vulnerable to fraud and abuse. Can you quantify the extent of the abuse by pass-through?
Yes, sir. Since the last GAO report, we put a lot of effort into making sure that the Veterans First program is not vulnerable to fraud and abuse. We've instituted post-verification audits of our eligible firms. We're doing about 100 of those a month. To date, we have found less than 3% of the firms that we audit. We go on site, look at the firms, look at their documentation. They are unannounced audits. Sometimes veterans do not appreciate the need to do that, but we appreciate the need to ensure the integrity of the program, and we have found less than 3% to be ineligible at the time we audit them. So we think that the process that we use to verify firms is a very solid one. It sets the standard for the federal government, and it's been successful. This bill, however, speaks to a different issue, which is the issue of limitations on subcontracting, which is not directly in the purview of my office, so I'm going to step out on a limb a little bit to talk about what contracting officers do. Contracting officers do monitor the performance of prime contractors, and our Office of Acquisition, Logistics, and Construction has put together a program where we go out and we do a subcontracting review. They also go on site, they look at documentation to determine whether or not prime contractors are both meeting their small business or subcontracting goals, and to ensure that limitations on subcontracting are met.
I didn't understand, Mr. LENEY. Who does this? It's not your office. Who is the office actually following through on that?
This falls under the Office of Acquisition, Logistics, and Construction.
Okay. Have they had a chance to review the bill or any testimony from them, Mr. Chairman?
They have not had a chance. We have not had a chance to discuss the final bill that you presented. But like I say, we do have a program because we agree that it's important to ensure, particularly that prime contractors, when we provide awards to service-disabled veteran-owned small businesses or any business, that or any small business, that they comply with the limitations of subcontracting. And that's the reason the VA established that program. So we would do additional reviews. They do it on a random basis and based on a risk assessment if they determine that there is a concern that a small business is not meeting its subcontracting.
How would they know if there was a concern if they're not?
If a contracting officer has evidence that this might be going on, they can refer a small business to this program, and they go out and do an audit.
Who would make the reference? Who would refer that?
A contracting officer. The contracting officers are the people that have the responsibility to ensure that the contract is properly implemented. And so they monitor the work of the prime contractor, and they monitor the amount of work that is subcontracted out.
Well, as I read the OIG report and various other reports, that therein is the concern, that even though you say they monitor it, they have not done that adequately. And some real concerns. We have this set aside for veterans, and I think the VA should be concerned if there's evidence that the work's not being done as required under the law by veterans. And I think we're going to hear testimony later from veterans organizations that would expect that to occur. But as you know, the false statements by contractors are already a violation of the law. And this bill is pretty simple. It just says they have to submit and that they understand that. That helps prosecution later on if and when it's found that there's some evidence of fraud and abuse in the system. Again, I know this committee is committed to making certain, and certainly the Small Business Committee as well, to make certain that the work is done as required under the law, and we just want to provide tools to the prosecutors to make that happen. With that, Mr. Chairman, I yield back.
Thank you, Mr. Huelskamp. Our thanks to the panel. You are now excused. I now welcome our second and final panel to the witness table. On this panel, we will hear from Mr. Gregory Wilshusen, Director of Information Security Issues for the Government Accountability Office, Mr. Raymond Kelley, Director of National Legislative Service for the Veterans of Foreign Wars of the United States, Ms. Diane Zumoto, National Legislative Director of AMVETS, Mr. James H. Binns, Chairman of the Research Advisory Committee on Gulf War Veterans Illnesses, Mr. Davey Leghorn, Assistant Director of the Veterans Employment and Education Division of the American Legion, and Mr. Frank Wilton, Chief Executive Officer of the American Association of Tissue Banks. And all of your complete written statements will be made part of the hearing record. Mr. Wilcherson, you are now recognized for 5 minutes.
Chairman Kaufman, thank you very much for the opportunity to testify today on this hearing related to some proposed legislation, particularly the one related to information security at the VA. Before I begin, though, I'd like to recognize several members of my team who were instrumental in developing my written statement. With me today is Tyler Montjoy, and also back at the office, Jeff Knott, Jennifer Franks, and Lee McCracken. And these individuals will be involved with our ongoing review of information security at VA. The use of information technology is critical to VA's ability to carry out its mission of ensuring that veterans receive proper health care, benefits, support, and memorials. However, without adequate protections, the VA systems and information are vulnerable to exploitation by a wide array of cyber-based threats, potentially resulting in, among other things, the compromise of veterans' personal information. GAO has identified information security as a government-wide high-risk area since 1997, and the increasing number of security incidents at VA further underscores the need for the department to implement appropriate security over its systems and information. Our work has shown that the Department of VA continues to face long-standing challenges in its information security program. From fiscal year 2007 through 2013, we noted that VA has had weaknesses in each of the 5 major security categories that we track over that period of time in each year. And these include those controls that protect and limit and detect unauthorized access to its systems, controls such as configuration management, which are intended to ensure that only authorized programs are in operation and are current and apply appropriate patches, segregation of duties, contingency planning, which is also intended to assure that disruptions in service are minimized and prevented to the extent possible, and importantly, security management. And these are the controls that establish the governance and assure that controls are tested and known weaknesses are remediated in a timely manner. For the 12th year in a row, the VA IG has identified information security as a material weakness, which is the most significant kind in its audit of the department's financial statements. In addition, the IG has noted that it is a major management challenge for the department to effectively implement its security program. Our work that dates back to the 1990s show that these weaknesses have been persisting for a very long time. And to help address this, we know that the subcommittee is considering draft legislation which is intended to improve and help VA improve its information security program. I would like to point out that the draft legislation allows for and provides that the VA implements very security objectives as well as some very specific security control activities. In certain instances, the changing technologies, cyber threats, and business practices at agencies introduces risks that very specific control activities that may be appropriate today may not be appropriate tomorrow. And so we suggest that by emphasizing the need for VA to focus on the security objectives and ensure that the security activities that are identified are implemented on the basis of risk will help to assure that those objectives are being met and could result and VA improving its information security. Mr. Chairman, that concludes my statement. I'll be happy to answer your questions at the appropriate time.
Thank you very much. Mr. Raymond Kelly, Director of National Legislative Services for the Veterans of Foreign Wars of the United States.
Thank you, Mr. Chairman. On behalf of the men and women of the Veterans of Foreign Wars and our auxiliary, thank you for the opportunity to testify today in regards to H.R. 3593, the VA Construction Assistance Act of 2013. It is well documented that the Department of Veterans Affairs struggles to complete major medical facility construction projects on time and on budget. Currently, VA has an average project delivery delay of 35 months and an average cost overrun of more than $300 million. VA is in the process of building 3 medical centers, each of which has been met with their own unique problems that have caused VA to lose time and money that could have been used on other projects. VA has a list of major construction projects that will cost more than $20 billion to complete. Every effort must be made to ensure every dollar is used efficiently so VA can close these major construction gaps. H.R. 3593 will help VA achieve these goals. Section 3 of this bill calls for 5 specific reforms to VA's major medical facility construction process. They are: use medical equipment planners, develop the use of project management plan, peer review project management plans, develop a metrics to monitor change order processing, and use design build process when possible. Using medical equipment planners places the experienced medical expert or equipment expert at the disposal of the architect and the construction contract. When used properly, the medical equipment planner can work with the architect during the design phase and then the construction contractor during the build phase to ensure needed space, physical structure, and electrical support are adequate for the purchased medical equipment, reducing change orders and work stoppages. Poor communication within VA and between VA and the general contractor has also led to delays and cost overruns. By developing and using project management plans, all parties at the onset of the project will have clear understanding of the roles and the authorities of each member of the project team. Included in the plan will be a clear guidance on communication, staffing, cost and budget, as well as change order management. Construction peer excellence reviews are an important aspect of maintaining high level of construction quality and efficiency. These reviews provide important feedback, a separate set of eyes on the project management plan to ensure a plan is in place to make the project come in on time and in on budget. The VFW believes that VA should migrate from a design bid build to a design build model of construction management. A design build project teams the architect and engineer company and the construction contractor under one contract. This method can save VA up to 6 months of time by putting the design phase and the construction performance metric together. Placing the architect at the lead from the start to finish and having a prime contractor work side by side with the architect allows the architect to be an advocate for VA. Also, the architect and the prime contractor can work together early in the design phase and reduce the number of design errors and also allow them to identify and modify building plans throughout the project. The VFW agrees with the recommendations outlined in Section 3 of this legislation. Section 4 calls on VA to enter into an agreement with the Army Corps of Engineers so the Corps can provide a special project manager to conduct oversight of the construction operations regarding compliance of acquisition regulations and monitor the relationship of VA and the prime contractor at the 3 ongoing projects in Denver, Orlando, and New Orleans. The VFW supports this provision, but it should be a stopgap measure to help VA to quickly complete these 3 outstanding major construction projects, and systems must be put in place to ensure VA can function under a similar guidance without the assistance of the Corps in future projects. It is important for VA to become more efficient at facility construction. Veterans have expectations that medical facilities will be available when VA first states that the completion date will, when they state the completion date will be. It is obvious by looking at the number of delays and the cost overruns that the contracting and building procedures that VA currently use are inadequate and are costing VA millions of dollars more for each project and causing 5 to 6 years delay on much needed medical facilities. By passing this legislation, VA will gain better oversight and cost controls and more efficient procedures for future construction projects. Mr. Chairman, this concludes my testimony, and I look forward to any questions you or the committee may have.
Thank you, Mr. Kelly. Ms. Diane Sumoto, National Legislative Director of AMVETS. You have 5 minutes.
Chairman Kaufman, Ranking Member Kirkpatrick, and distinguished committee members. While I'm pleased to have the opportunity to sit before you today, I'm simultaneously disheartened that it's because we're dealing with administrative issues rather than making progress towards the understanding and treatment of the scourge that is Gulf War illness. If we expect to understand Gulf War illness, if we ever expect to develop medically appropriate treatments for it, and if we ever hope to truly improve the quality of life of our Gulf War veterans, then business as usual can no longer be accepted. 23 years have passed since the end of the Gulf War, and 16 since Congress first mandated the appointment of a public advisory panel of independent scientists and veterans to advise on federal studies and programs to address the health consequences of the Gulf War. AMVETS' sole interest in seeing this legislation enacted is the health and therefore the quality of life of our Gulf War veterans. For all these years now, these men and women have suffered and continue to suffer from the often debilitating effects of Gulf War illness. How much longer are they to be expected to wait to get relief from their decades-long pain and distress? AMVETS believes this legislation, H.R. 4261, the Gulf War Health Research Reform Act of 2014, can be an important part of the solution that Gulf War veterans have been waiting for all these years. AMVETS fully supports H.R. 4261, which would establish the RAC as an independent committee with authority over budget allocations, staffing levels and expenditures, personnel decisions, processes, procurements, and other administrative and management functions. This is perhaps the most important provision of the legislation. It would also require that the majority of the RAC members be appointed by the chairman and ranking members of the House and Senate Veterans Affairs Committees rather than the VA. This provision means that the RAC will not become just another part of the VA. It will also strengthen the RAC's ability to review research and studies, as well as publish reports related to Gulf War illness. The ability of the committee to freely make and publish recommendations, reports, etc., increases transparency and positively adds to the body of work on Gulf War illness. The legislation also expresses a sense of Congress that VA should contract with the Institute of Medicine to conduct several Gulf War studies and reports previously ordered by Congress, which were not conducted or weren't conducted in accordance with Congress's direction. Until the right questions are asked and the correct studies are conducted and considered solutions will not be found. It also requires the VA to ensure that research conducted on this disease be referred to as Gulf War illness. It's time for the VA to call this condition by its commonly accepted name. And with regard to future research, it would require that the Institute of Medicine reports on the health effects of veteran toxic exposures consider animal as well as human studies, as Congress has previously ordered, to better understand the causes and how best to treat our afflicted veterans. Since its formal establishment in 2002, the RAC's charter has undergone a series of minor changes, including in April 2014, May 2006, May 2008, and November 2010. Until May of 2013, there had not been any fundamental changes made to the committee's charter. All that changed with the stroke of a pen on 17 May 2013, when the independence, oversight role, and the provision providing the committee with authority over its own staff and budget were eliminated. With this action, it appears that the RAC has essentially been turned into nothing more than an internal VA advisory committee operating strictly under VA's authority with little to no connection to the national community. I'd be happy to answer any further questions.
Thank you, Ms. Zumato. Mr. James Ben, Chairman of the Research Advisory Committee on Gulf War Veterans Illnesses.
Thank you for the opportunity to testify in support of H.R. 4261. Since Congress created the Research Advisory Committee on Gulf War Veterans Illnesses, our members have testified at 10 congressional hearings. This is the last time a committee member will freely testify without VA censorship unless this bill becomes law. Gulf War illness is a serious disease associated with service in the war, affecting 250,000 veterans. It cannot be explained by any psychiatric illness and likely results from environmental exposures. Effective treatments can likely be found with the right research. These are the conclusions of the Institute of Medicine. Next month, our committee will release a 5-year report that shows research is making progress. But just as science is turning the corner, career VA and DoD staff have attempted to revive old fictions that the same thing happens after every war due to psychiatric factors. Because there is no evidence to support this position, they have resorted to manipulating research to provide apparent support. In its recent survey of Gulf War veterans, the VA Office of Public Health included the questions to identify PTSD, but not Gulf War illness. In a medical journal, the heads of the 3 VA war-related illness and injury study centers wrote that the illness, quote, has been documented after armed conflicts since the Civil War, and that a biopsychosocial approach will most benefit the patient. The list goes on. VA's talking point says that it does not support the notion that some have put forward that these health symptoms arise as a result of PTSD or other mental health issues. But the some who are putting these notions forward are VA staff. These actions threaten to mislead science down blind alleys once again, just as has happened for most of the last 23 years. Our committee has been charged since its inception with assessing the effectiveness of government research. We complimented early progress under Secretary Shinseki, but when staff launched this campaign, we reported it and asked the Secretary to investigate and remove those responsible from Gulf War research responsibilities. Instead, VA removed us. In May of last year, I was notified that the committee's charter had been changed to eliminate its charge to assess the effectiveness of government research, and that the membership of the committee would be replaced over the next year. Fresh blood is certainly desirable, but 2 of the 3 scientists subsequently proposed for membership by VA were stress advocates. One has edited a textbook on stress and is a member of the American Psychosomatic Society. VA has sought to backtrack, pulling these names and appointing others, but they have shown where they intend to go once they are no longer under scrutiny. VA has attempted to explain the charter changes as necessary to comply with the Federal Advisory Committee Act, or the committee's work, or that the committee's work is an inappropriate oversight. Virtually identical language has been part of 5 charters signed by 4 secretaries, including Secretary Shinseki. All recognized that an inherent part of advising on future research is to assess the effectiveness of the research already being done. The clear purpose of the charter change was to stop our committee from reporting on staff efforts to mislead research, and that is exactly the effect it is having. Attached to my testimony is the draft section on VA's research program, which had to be removed from the report our committee will release next month. In addition, VA has recently stated that committee members may not release reports without written VA approval. H.R. 4261 gives back to the Research Advisory Committee the responsibilities and independence VA has taken away. Ms. D'Amato has already summarized the terms, so I will proceed to state that this bill is vital to maintaining the hope that progress toward effective treatments will continue. But restoring the committee only gets us back to where we were, advancing science in one area while the staff pulls it back somewhere else. That is what has happened for most of the last 23 years. If the IOM is correct, and I believe it is, that effective treatments can likely be found with the right research, then Gulf War veterans would likely have effective treatments today, but for this staff obstruction. Unless staff obstruction is removed once and for all, science candidly may never reach this goal. VA leadership has decided to shoot the messenger instead. I urge Congress to go beyond this bill and pursue a rigorous investigation necessary to end this shameful history and clear the way ahead.
Well, thank you so much for your testimony. I just got to say, as a Gulf War veteran, I want to thank you both, Ms. D'Amato and Mr. Benz, for your attention on this issue. I just think it's so disgraceful how our Gulf War veterans have been treated on this issue. Mr. Davey Langhorn, Assistant Director of the Veterans Employment and Education Division of the American Legion.
Chairman Kaufman, Ranking Member Kirkpatrick, and distinguished members of the subcommittee. On behalf of our National Commander, Dan Dellinger, and the 2.4 million members of the American Legion, thank you for the opportunity to submit the views of the American Legion regarding the bill to improve the oversight of contracts awarded by the Secretary of Department of Veteran Affairs to veteran-owned small businesses. Many of our veteran small business owners are at a disadvantage when they have to compete with companies that don't actually complete more than 50% of the required work of contracts that are specifically set aside for service-disabled veteran-owned small businesses. The purpose of a veteran set-aside contract is to bolster the capacity of the veterans' small business industrial base, and likewise for contracts designated for service-disabled veteran-owned small businesses. When the majority of this money ends up going to non-qualifying businesses by way of a pass-through company, the good intentions of Public Law 109-461 become meaningless. This is why the American Legion passed Resolution 73, which endorses legislative efforts to ensure that contracts awarded pursuant to the Veterans First program are awarded to companies that truly are entitled to receive these set-asides. The American Legion advocated for Public Law 106-50, which made all federal agencies stakeholders in supporting veterans entrepreneurship. The American Legion also supported Public Law 109-461, which provided VA with the authority to set higher agency standards for SDVOSB and VOSB set-asides. VA refers to this program as the Veterans First Contracting Program, or Vet First. The American Legion has vested interests in and is very protective of the programs we help institute within the federal government. This is why we support legislation that would increase programmatic oversight and increase penalties for bad actors who maliciously seek to defraud the federal government. Regarding a certification of good faith to the Secretary, the American Legion believes that this is a solid step in ensuring our veterans fully understand the rules when bidding on and accepting prime responsibility for federal contracts, and also understand what the penalties are for making false claims and statements. However, fraud and abuse is neither rampant nor exclusive to the veteran small business community alone. Other disadvantaged small business programs have come under scrutiny in the past, yet they are not held to an extra administrative hurdle. The American Legion is concerned with the message this administrative step sends to the small business community and the public as a whole, and would support similar scrutiny and administrative safeguards across the federal procurement landscape. The American Legion understands the intent of this certification, and we caution this committee to ensure that we are not singling out the veteran small business community as the only program that might need safeguards. This extra administrative step would be easier for the veteran small business community to accept wholeheartedly if it were instituted among all other disadvantaged small business set-aside programs as well. Again, the American Legion supports this bill, but ideally we would prefer to see the same standard being applied not only within 38 CFR, but extended to 13 CFR as well. Lastly, regarding the bill's congressional reporting mechanism, the American Legion agrees that an independent entity such as VA's Office of the Inspector General or the Small Business Administration should conduct a report on VA OSBU's oversight. OSBU's main role is small business advocacy within the agency. The report is an acquisitions issue that falls outside of OSBU's purview, so the American Legion would go as far as to recommend that aside from minor aggregate reporting, OSBU be completely removed from the referral and reporting process in ensuring that the report submitted to Congress is unbiased. In conclusion, the American Legion believes that the responsibility is upon all the stakeholders to ensure that we become better stewards of the Veterans First program. The American Legion will continue to work with the Small Business Administration and the Department of Veteran Affairs to increase contracting opportunities for our veteran small business owners and to ensure that the money allotted for these set-aside contracts stay within our community. The American Legion appreciates the opportunity to testify today. Again, thank you, Chairman Kaufman, Ranking Member Kirkpatrick, and members of this subcommittee for allowing the American Legion to present its views on this bill.
Thank you, Mr. Leghorn. Mr. Frank Wilton, Chief Executive Officer of the American Association of Tissue Banks.
Chairman Kaufman, Ranking Member Kirkpatrick, and distinguished subcommittee members. Thank you for the opportunity to come before you today in support of the Biological Implant Tracking and Veteran Safety Act of 2014. This critical legislation directs the Secretary of Veteran Affairs to adopt a standard identification protocol for use in the procurement of biological implants. By building upon the Unique Device Identifier, or UDI, this legislation will ensure that biological implants can be appropriately tracked from the donor of the human tissue all the way to the recipient. This critical capability for track and trace efforts will enhance patient safety, expedite product recalls, and assist with inventory management. This legislation takes a bold step to expand the application of the concept of the UDI to all tissue products, including those tissue devices which are already covered by the UDI, as well as another product category, certain biological implants, or, as termed by the Food and Drug Administration, 361 HCTPs. While many of the biological implants do have barcodes, by requiring a standardized format as outlined in this legislation, it is easier for the Department of Veteran Affairs medical facilities to utilize universal barcoding conventions. As the Secretary of Veteran Affairs opts to adopt the standard identification protocols for tissues, both devices and non-devices, I urge you to ensure the Secretary to provide a menu of options. Under the UDI final rule, FDA has done just that by providing for multiple entities called issuing agencies. At this time, FDA has provided for 3 different issuing agencies: GS1, Health Industry Business Communications Council, HIPC, and ICC-BBA. I hope that this flexibility is maintained within the Department of Veteran Affairs. However, given that the bill language already suggests that the unique identification system is comparable to what the UDI provides, we believe the intent to provide that flexibility is inherent in the legislation. For those of you unfamiliar with my organization, the American Association of Tissue Banks is a professional, nonprofit, scientific, and educational organization. The association was founded in 1976 by a group of doctors and scientists who had started in 1949 our nation's first tissue bank, the United States Navy Tissue Bank. It is the only national tissue banking organization in the United States, and its membership totals more than 125 accredited tissue banks and 850 individual members. These banks recover tissue from more than 30,000 donors and distribute in excess of 2 million allografts for more than 1 million tissue transplants performed annually in the United States. The vast majority of tissue banks that process tissue maintain AATB accreditation. First published in 1984 and presently in its 13th edition, the AATB standards for tissue banking are recognized as the definitive guide for tissue banking. The AATB standards have served as the model for federal and state regulations, as well as several international directives and standards. Currently, the statutes or regulations in 19 states reference AATB standards, institutional accreditation, or individual certification. Given the wide acceptance of AATB standards, I would be remiss if I didn't mention one aspect of the legislation which is disappointing. The current legislation lacks a requirement that biological implants purchased by the VHA be procured from accredited tissue banks and accredited tissue distribution intermediaries. While I understand that there may be some concern about imposing such a requirement because AATB is a private entity, I would just note that there are other instances in which the VHA has decided that private accreditation is not only appropriate, but required. Specifically, the VHA requires medical facilities to receive and retain accreditation by the Joint Commission, a private accrediting agency. Leading medical centers of excellence require AATB accreditation of vendors from whom they procure tissue grafts. In addition, the American Academy of Orthopedic Surgeons recommends the use of tissue from banks that are accredited by AATB. By not requiring that vendors adhere to the highest safety standards required by the AATB's accreditation process, I remain concerned about the overall safety and quality of the products provided to our veterans. I welcome your questions and yield the remainder of my time.
Thank you for your testimony. Mr. Kelly, what do you believe explains the lengthy delays and overruns in VA major construction projects?
Unfortunately, I think sometimes politics gets in the way within VA, within the community, within Congress. Everybody's got their vision of what it should be, and the ball starts rolling. Those visions change along the way to meet the needs of the politics, not necessarily the veterans. And then as that works out, the needs of the veterans are taken into account.
Mr. Benz, please briefly describe how VA has interfered, undermined, or impeded the work of the RAC.
Well, VA has removed our charter's charge to review the effectiveness of government research. That means that you, the Secretary of Veterans Affairs, and the public will not know what an independent body of scientists and veterans considers is happening within VA research. And as you will see from reviewing the draft, which had to be removed from our report, which I've attached to my written testimony, that is a serious indictment indeed. The latest action that has been taken is that each committee member in the letter inviting them to attend the next meeting, which we are asked to sign, acknowledges that we will not share any information, reports, recommendations produced at the meeting without the written approval of VA. Even the pretense that the committee is independent has been removed. So you will not ever hear from a RAC chairman in the future, I can assure you, who has not had each and every word of his testimony vetted and written for him or her.
Ms. Sumato, what does autonomy for the RAC accomplish for Gulf War vets?
Well, I think that certainly the more people we have involved in this process, and the more, I don't know if I want to say competition, but it shouldn't, this is not something that should be handled by one organization or one agency. And so having the RAC and having them being able to provide an individual opinion on what is happening in the VA, I think is only a positive thing. I think our veterans are going to benefit by having that, having another set of eyes on what's happening.
Very well. Mr. Kelly, your testimony mentions cost overruns and adversarial relationships between VA and contractors. there was evidence that such problems occurred in Denver or in Aurora, and possibly other sites where VA asked for bids based on the presumption that it would produce, in the situation of Aurora, a $600 million project. But it appears VA has produced a project potentially much more expensive than that in terms of its design, which they provided 8 months after the bid process was completed. What should VA do to maintain control of construction designs in the future?
I think going to the design-build model will help. It puts the contractor in the process early on in the process. So you don't get an architect who's got a grand design of a beautiful building that might not be practical. And then when the build starts, the contractor has to come in and say that this space isn't going to be right. And then there's confrontation between the contractor and the architect, which also puts conflict with what VA's had asked for to begin with and what the outcome's going to be. So I think putting those two together at the very beginning of the process, so the architect and the contractor are on the same page, that the outcome will be cheaper, because you're not running into cost overruns when you bid on a design and then you realize, well, what we need in here isn't going to fit in the design that we have, and we have to go back and fix this. Now we've got change orders, we've got design redos that increase time, increase cost.
Thank you, Mr. Chairman. I join the chairman in thanking you, Ms. Amato and Mr. Benz, for your attention and your work on behalf of the Gulf War veterans and keeping the attention focused on the illness. You've been a great resource to my office, Mr. Benz, and I don't really have any questions, but I just wanted to thank you for being here today and for the work that you're doing. I want to ask a question about the tissue barcoding. Mr. Wilton, one of the things that we're working on is trying to get a same formulary in the Department of Defense as we have in the VA. And we're finding that that's a little more difficult than we thought it might be. So can you tell me if the Department of Defense uses the barcode that you're proposing for the VA?
Yeah, I think one of the benefits of this will be that as it becomes universal, it will be used in all of the healthcare settings. So not only DOD, but VA, but also in other healthcare settings. So I don't believe they currently do, but we would certainly support the use of it in other settings.
Okay, that's something that, if we're able to be successful with this legislation, that I'd like to work with you on, because we are having joint meetings between the top physicians at the VA with the top physicians at the Department of Defense, ultimately with the goal that we'll be able to have one good medical record transitioning out of the military into the VA system. So thank you for that.
We would welcome the opportunity to work with your office on that.
Thank you. Mr. Leghorn, I recently visited some military bases, and my role really was to talk to military members who are soon transitioning into the VA and what we could put in place for them while they're still in service to make that transition easier. And the number one issue was jobs. They said, they were really concerned about where they would find work, how they would find work. So I appreciate your emphasis on hiring vets, but in recent meetings with some of our veterans groups, there's certainly a feeling, I haven't looked into this in terms of really investigating, but there's a feeling that all of these programs are great, but there's no enforcement, that people or businesses are really overlooking the programs. There's no teeth in this legislation to make sure that veterans are indeed being given preference. Has the American Legion done any studies, any research into that?
Not that I know of, no.
Okay. Is it something that you're hearing that you would agree maybe needs to be done?
Absolutely.
Let me ask you too, then you're proposing safeguards. Do you think internal safeguards are better than some kind of external oversight in terms of enforcement?
In terms of the safeguards that was mentioned in the bill, we feel it to a certain extent it is necessary. We're just concerned about the messaging that it sends to the community, because we're enforcing this safeguard only on the veteran small business community, and we're not applying it to everyone else.
In the singling, I understand that, just the small business veterans community is being singled out, I am concerned about that. I just was trying to bring it into a larger context, but thank you for your testimony. My last question is for you, Mr. Wilson. In your written testimony, you state that emphasizing that specific security-related actions should be taken based on risk could help ensure that VA is better able to meet the objectives outlined in the draft bill. Would including a risk assessment make the specific actions addressed in the bill discretionary rather than mandatory on the VA?
It would make it based upon the risk, because one of the factors that should go into risk management and security controls is the fact that every single control may not be appropriate in every single circumstance. And that according to FISMA, which is the overarching law for information security, agencies are supposed to perform risk assessments and then design and implement security controls based on the effect on the results of those assessments to assure that they're able to cost effectively reduce risk to an acceptable level. Now, there's judgment involved with those risk assessment and which controls should be in place. But federal guidelines specify that there are a number of security controls that should be considered depending upon the significance or the categorization of the system, which relates to the impact that could occur should the information be compromised. But it does allow for some leeway, because in terms of determining when a control should be implemented and maybe not. I think with many of the specific controls that are identified in the draft bill are based on sound security practices and are consistent with federal guidelines. But as I mentioned, building it into allowing and assuring that those controls are implemented on risk and are intended to meet the security objectives within it allows some flexibility for those controls and security practice to evolve naturally over time as conditions change. Because a specific control that may be appropriate in one circumstance, that same control may not be appropriate in another circumstance due to changing conditions.
It makes common sense to me that there be some flexibility, but, Mr. Chairman, I have some concern about there not being some benchmarks to make sure that happens in a timely manner. Thank you very much. I've gone over a little bit. Thank you for your indulgence.
Dr. Rowe.
Thank you, Mr. Chairman. Just a couple of comments and a couple of quick questions. Mr. Wilton, if you would, on the tissue banking, I agreed with much of what you said. Is there any reason for the VA not to do what's outlined in the draft?
I cannot come up with one, Congressman. I think it makes good sense, and I think that, who better to make sure that we're protecting than the men and women who've served this country so nobly. So I can come up with none.
I agree with you, and I think one of the things that will happen ultimately, it'll be unintended on anybody's part, but we've seen where something happens and then there's a delay in notification of the veterans about this particular issue. And I've used these products before, and there are tracking systems out there in the private world. Secondly, just briefly, are there any other accreditation other than what you mentioned? And I think one of the reasons it was left out was in the draft legislation, and maybe it should be put in, are there other agencies that accredit, not just that one you said? It's a private agency, as I understand it, that does that accreditation.
Within the tissue banking profession, we are the only one, and quite frankly, considered the gold standard within healthcare. Most leading centers of medical excellence, as I mentioned in my testimony, will only source tissue from AATB accredited banks. So we think, again, why wouldn't the VA want to get the best?
Okay, thank you. And Mr. Ban and also Ms. Zamato, just a couple of comments. One of my pet peeves in the practice of medicine over the years was if we didn't know what was wrong with you, is either in your head or was a virus, when we didn't know. So I think that basically what we need to do is exactly what you've said, and I think the VA somewhat has done that, but to take the RAC, to get the Institute of Medicine, to study this like you would any other issue, and then come to a conclusion, whatever it is. And whatever the conclusion is, I could not agree more with that. And to put this to bed, and I want to thank our chairman for his service at Desert Shield and Desert Storm. And there are many veterans out there that just would like to have an answer to this, an objective answer in an unbiased setting. So just a comment there. And Mr. Kelly, just a couple of things. One, I agree, and I think the VA did a great job of describing the design build and design bid build. Sometimes what you do if you have a design build process is you eliminate a lot of smaller builders who don't have an architect in-house. Most of the design builds are big firms that have an in-house architect. And I can think of many instances in my area where very, very good builders couldn't bid on a design bid because they're not big enough. And there are situations where I've seen it in literally hundreds of millions of dollars worth of construction in the design bid build that works fine. And I just want to make that point that it's not the only way to do that. And the VA, I think, described that extremely well. And I guess my last question is to Mr. Welshusen. What should the VA be doing now that they're not doing? I listened very carefully to your testimony and read it, but what if they were doing something now, what would you say they need to implement right now?
I think it would be to redouble their efforts in resolving and mitigating and taking corrective actions on known vulnerabilities. They have a large number of outstanding security vulnerabilities that have been existing for quite some time. So taking actions right now to assess the risk of those, identify the most critical ones, and act on that and take corrective action immediately would be something that they should do.
Yeah, I think we've noticed, we know that literally there are people trying to hack into these systems, foreign governments. We've had that testimony right here in this committee, this subcommittee about that, and it's a moving target. I understand maybe I don't even understand how hard it is. It's so complicated. But I guess the question I would have, if they can implement anything now that would be effective, what should they do? Because every phase of government has it. Private businesses have it, medical records, everything that we do that's online is now being, really is vulnerable.
Well, it certainly is, because with the extensive use of information technologies across the federal government, and it's VA and other agencies too, there's inherent risk with the use of those technologies, particularly as it becomes more interconnected with other systems, other organizations, external and internal to each department. But the one thing that, there's a number of things that agencies and VA needs to do. And one of the first things in terms is shoring up and making sure, for example, that they take corrective actions to assure that the systems that they operate have the appropriate patches installed, that they implement the appropriate security controls to harden, to prevent and limit access to their systems. But again, it gets back on doing that.
Well, do they need legislation to do that, or could they just do that now?
They should be doing it now, but apparently, in VA's case, they may need this legislation, the proposed bill, may help prompt them to refocus their efforts to take the necessary actions to protect their systems.
Okay, thank you. I yield back.
Thank you, Dr. Rowe. Ms. Walorski.
Thank you, Mr. Chairman. Mr. Welshusen, with all the weaknesses that you've cited in the conversation that you and Dr. Rowe just had, has the VA made any improvements to its information security program?
Well, according to the OIG at VA, the department has taken steps to implement a continuous monitoring program, as well as to standardize many or several of their security configurations. And if those are designed and implemented effectively, that could result in some security benefits. But as you may know, we've been asked by the subcommittee to review the weaknesses and vulnerabilities at the Department of VA on their information security. We plan on looking at the extent to which those vulnerabilities continue to exist, the extent to which VA has taken actions to mitigate them, and the extent to which those vulnerabilities help to expose veterans' information and to compromise. And so I'll have more on that issue for you later as we complete that particular review. We're just starting it at this point.
So this is your first review of their internal security documents?
Not the first, at the present time, yes. For years, we have reviewed information security.
Right.
Time. But for this particular effort and these vulnerabilities, yes, we're just starting that for this year.
And given the current federal information security requirements and VA's known material weaknesses, do you believe that this IT directive can assist VA in addressing those weaknesses if implemented?
Yes. I think these actions identified in the directive are intended to address known vulnerabilities that exist in VA now. And so to the extent that they take those actions, again, on a risk-based basis, that it should help VA improve its security.
Well, and just to echo Dr. Rowe's comment and your comment as well, is legislation needed? I honestly, having sat on this committee, think that it's a directive that has to be implemented at this point because there's no voluntary compliance. So the mere suggestion from Congress asking and asking and asking, and then having your department follow up and the reports that continually come back with vulnerabilities, I mean, it's just my opinion. Our veterans deserve more. There are so many people that come in here and testify on so many different issues, and I appreciate all of your testimony today. But when it comes to protecting identities and healthcare records, and there isn't a day that goes by in the local news and national news where we're not talking about protecting the most important data that we all have, which is our identity, and now in this case, health records, and now we're talking domain controllers, and we're asking questions about foreign entities having access. I just think there's an urgency involved. So I appreciate the work that you do and all of you in your testimony today. Thank you, Mr. Chairman. I yield back.
Thank you, Ms. Walorski. Mr. Hulskamp.
Thank you, Mr. Chairman, Mr. Leghorn. I appreciate your testimony. I appreciate the Executive Committee on their resolution that endorsed efforts such as these to make certain that contracts are awarded to companies that truly are entitled to receive these set-asides. I think that's very critical. Appreciate your efforts on that, and my office is more than willing to, if you hear of examples and cases that perhaps the VA has not acted on quickly enough, let us know, and we'd be happy to look into those as well, because I think if we're going to have a program such as this, we should do everything we can to make certain that it goes to veterans. So I appreciate that. I do have one small question for the gentleman from the GAO in reference to apparently 12 years of reports and studies, and I congratulate my colleague for introducing the bill. But I will say that the testimony we heard in this subcommittee about how vulnerable this system was and it's probably been the most shocking I've heard in this committee in over 3 years, and I appreciate the efforts, and I know my colleague asked the question, do you think they're making progress, and it's not nearly enough. But do you have any evidence or ability to share that will give us an example of, if we compared this to a private sector entity, what standard we're meeting out in the world outside of government in terms of meeting those security requirements? I have a lot of my colleagues that always want to talk about these private companies, and rightly so, that are not secure enough with data. Then we have these shocking reports of 20 million veterans and their families, their medical records, financial records were hacked. The VA refused to actually said it did not occur. A whistleblower said otherwise. But is there a standard we can look at and say, here we are compared to the private sector?
Well, in terms of the information security requirements that federal agencies are to implement, they tend to be as stringent as those perhaps available to the private sector. One can look at the news media, and we haven't examined the security controls at very many private sector companies. When we've identified vulnerabilities that also put those entities' information at risk. But you can look at the papers, and just with Target and a number of other companies, there are security breaches across the board. Many are reported, many are not. It's just emblematic, I think, of the fact that that agencies, private companies need to protect the information. It's a challenging proposition. There are many things that can be done to help raise the bar in protecting that information. Many of the actions identified in the draft bill are among those types of controls if implemented on a risk-based basis. But it's something that is a fact of life in our environment, and it's in large part because agencies, I won't say agencies haven't taken it seriously, but you're right, there's much more that needs to be done in order to adequately protect the information that those individuals who provide their sensitive personal information to agencies entrust and deserve.
All right. I yield back. Thank you, Mr. Chairman.
Thank you, Mr. Yuleskamp. Thank you. The panel is now excused. I again want to thank everyone for their participation today. The input and feedback provided is an important contribution at this subcommittee, as this subcommittee crafts legislation to improve the quality of service VA provides to our nation's veterans. With that, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous materials. With that, objection so ordered. This hearing is now adjourned. But so on that, when I was